So now let me introduce you Professor Winter. I hope that you can see him on the screen as our main speaker. And first of all, of course, I would like to thank Professor Winter very much for accepting to participate in our conference today as a keynote speaker, especially in these circumstances where the difficulties seem to be multiplied by hundreds, but we have overcome every difficulty, so it should have to work. And in fact, the preparation of this conference has forced us to learn quickly about these new tools for e-learning in both sides. Professor Winter is professor for public law, European law, and sociology of law at the University of Bremen since the 70s. There, he is also co-director, I think, of several research institutions. I want to mention also him as a founder of the Research Center for European Environmental Law. He was also founder of and still a member of the Aboseta group. That was the framework where we first met so many years ago. This is an informal group of lawyers who worked on European environmental issues. And since then, as I said, he's a member of several national, international research centers. And therefore, obviously, he has a great international prestige. This is one of the reasons that we are especially glad and we are very, very happy to welcome here at this conference at the University of Barcelona. As you probably know, some of you already know, his research focuses on different areas, of course, on the one hand, which is procedure organization of administrative decision making, and also, of course, material criteria, instruments, tools for environmental protection under national, European, and international law. And it's in that area that we have invited him for today. In that area of environmental law, he has published a lot, so I cannot just refer to all his articles and books. He just have a lot of them in the different aspects and different areas of environmental law, from habitat protection to climate change to precautionary principle and to biotechnologies. Actually, there are a lot of, he has a lot of experience on biotechnologies and law. And one of the last articles he wrote, I just sent you the link. It was about the case that he's now to talk us today. So multiple publications on the area of international law, which are of course a reference for all the academics or researchers who are working in that area. So he will present today about one important, very important case of the European Union Court of Justice, what is now as the Climate People case. That is a case brought before the European Court of Justice, in which the applicants also claim the European Union law not to be enough in order to guarantee their fundamental rights when environmental damage are supposed to be produced by the climate change consequences. So I think this is an important case, and it is a great occasion for having one of the professors from the academics who has been leading that case. So there is no any other, there's no better person to talk about that. And well, for that, I would like to again thank you very much, Professor Winter, for joining us today. I hope that everything will work fine. If anything happens, we will try to solve that immediately, but I just ask you for a little patience if anything happens, to give us time to solve. Okay, so thank you, Professor Winter, and you have now the floor. Let me just...
Okay, good afternoon, everybody. I'm a bit nervous, I must say, because of this new experience and even adventure to teach via electronic means. We have started in our semester at our university 2 weeks ago, and I had about 30 students, and that went quite well. But now we are many more, and I hope that we not only will have my presentation, but also discussions. So please feel free to put questions, and I will try to respond to them. Thank you very much, Mar, for your friendly introduction. Of course, this is overstating everything I have done, but I'm very thankful that I have now the opportunity to present my more recent engagement in the case, the Carvalho case, which is also called People's Climate Case. So let me first give you an overview of my talk. And here, let me see if I can bring this to the screen. I hope you can see it now.
Yes, perfect.
Yeah. And this is my talk. I will give a short overview of climate litigation as it is going on in different parts of the world, focusing on Europe, of course. Then I go into the case, and we will have a short video showing who the applicants are and what the case is all about. I propose to really present the case, but of course the case is at the same time a case study for more general problems, including access to the European courts, direct access to the European courts, and in substance, basic rights, fundamental rights as related to climate protection, as well as international law in the form of the Paris Convention as related to actual climate protection. And at the end of my talk, I want to initiate a little bit of a debate on theoretical consequences which may be drawn from the case, including questions of separation of powers. What role should the courts play here in climate protection policy? But also, if we have time, questions of in what respect the law can protect future generations, and also the question, what does a state or a community of state do in times of scarcity of resources? We are entering, I think, a phase of resources becoming scarce, and that's a new situation where we need to adjust the law and develop criteria of allocation of those resources to states and to the ordinary people. So I suggest we now start with an overview of court actions for better climate protection. Of course, there have been many court cases brought by companies which claim to suffer restrictions from too much climate protection. There are many cases on that, but our focus is today actions brought by people who suffer from not sufficient, from unambitious climate protection. And here, many cases have been brought already. Depending on criteria, one can talk about 500, some say 2,000 cases all over the world. If we try a structure, one could say there are cases where private persons go against private persons who suffer from climate change against private persons who caused climate change, like in the case of Luja versus RWE, a German utility, where a Peruvian farmer complains about the risk of being flooded by the water from melting ice in the Andes, and costs which have to be collected in order to build a dam to prevent the water from overflooding the village where he lives. So that's the category of private versus private actors. Then there is the category of private actors against public authorities. Very famous has become the Dutch case, Urgenda versus the Dutch government, where the claim was that the Dutch state has not reduced emissions of CO2 and other greenhouse gases as they should have done, applying basic rights, protection of citizens. And private-public was also the case, Juliana Kelsey versus US administration, where they also claim that more climate protection has to be introduced. They do not quantify the reduction of greenhouse gases, but rather, first of all, argue that the US government has not come up with any sensible program of climate protection. And there is now a recent case in France, Notre Affaire à tous, versus French government, which also invokes basic rights, arguing that the French climate protection policy is insufficient. Then we have also the constellation where public authorities go against private actors. And one case is, for instance, New York City versus BP, Chevron, Conoco, Exxon, and Shell, where New York City argues that climate change co-caused by these major utilities have caused damage to the city, to the infrastructure of the city, and so on. Finally, we have the structure public actors against public actors. The most famous case is here Massachusetts versus US Environmental Protection Agency, where one state of the union acted against the federation. Our case, the Carvalho case, belongs to the category of private actors versus public authorities. The public authority, in our case, being not a state, but the European Union. This is, in a way, unique that a regional community is also asked to do more. And we will come back to the problems this kind of case causes when it comes to application of admissibility and criteria and the substance of the case. Before we go into the case, I would like to show a video which gives you an impression of who the plaintiffs are and what they complain about. And Mar is friendly enough to show it, because technically I cannot do this from here.
I'm doing that. So, whoops.
Wir haben im Wesentlichen Klägerfamilien, die es mit Hitzewellen, Dürre, zu viel Wasser, zu wenig Wasser, Eisschmelze, Gletscherschmelze zu tun haben, wo wir also wirklich sagen können, hier ist der Klimawandel schon angekommen. Mein Name ist Dr. Rhoda Verheyen, ich bin Rechtsanwältin und ich betreue den Fall, wo es um die europäischen Klimaziele geht.
Eu sou o Armando Carvalho e de formação sou engenheiro florestal, e a dimensão, a severidade com que o fogo chega aqui é de tal ordem que nada resiste, O incêndio afetou praticamente todas as parcelas da propriedade, com devastações que nunca ninguém imaginaria que se pudesse ter.
Je m'appelle Maurice Féchet. Mon père et mon oncle avant en avaient déjà. C'est de tradition depuis très longtemps. Puis il y a une connotation, de vacances. Et on voit bien là que il y a des longues, voilà, il y a 5 ou 6 mètres de temps en temps là, qui sont mortes à cause de la sécheresse de l'an passé. Et ce problème-là, on le retrouve de plus en plus depuis une dizaine d'années.
Sunt o simplă persoană cu numele de Vlad Petru, de Deal. M-am născut sărac și țăran mor. Lipsă de ploi, când vin ploi, sunt ploile agresive, cu piatră și ne distruge recoltele, afectează și la animale. Aș dori ca și copiii mei să aibă un viitor aici pe pământul unde stăm, pe pământul strămoșesc, să nu mai plece cum am plecat eu în țări străine, să muncească.
Allen Familien geht es um dasselbe. Sie wollen ja keinen Schadenersatz oder so etwas, sondern alle wollen einfach nur, dass die EU ihre Klimaziele so ausrichtet, dass sie geschützt werden, so gut es geht. Und das ist ja eigentlich auch der rechtliche Ansatz des Falles. Tu, was du kannst, EU, sagen die Kläger.
Olha, eu sou o Hildebrando, sou apicultor. As alterações climáticas afetam as abelhas na totalidade, porque desequilibra o... Penso que isso é muito mau, porque a apicultura é cativante, a pessoa gosta das abelhas e depois começa a tratá-las como sendo um familiar. Tenho apicultores da minha idade e eu seria um caso desses, nunca conseguiria deixar as minhas abelhas.
Allora, mi chiamo Giorgio Elta, faccio l'agricoltore, ho una piccola azienda qua a Cogne. Il cambio climatico è qualcosa che non si riesce a percepire in maniera immediata, no? È qualcosa che ha un lento progredire ma molto continuo, no? Quando fai agricoltura hai delle conseguenze magari immediate sul tuo lavoro. L'anno scorso, a febbraio, ha fatto molto caldo, al 15 d'aprile, quindi come fosse pochi giorni fa, aveva fatto una gelata molto forte, no? Che c'era stata in tutto il nord Italia. Come i lamponi erano già tutti iniziato a germogliare, praticamente li ha seccati completamente tutti. Io l'anno scorso non ho raccolto neanche un lampone.
A história desta herdade é muito longa, está na responsabilidade da minha família há mais de 6 gerações. O meu nome é Alfredo Cunhal Sendi e eu sou agricultor há 30 anos. Conseguíamos dar trabalho, conseguíamos ter uma harmonia da paisagem na qual nos sentíamos bem, mas o que não é normal é uma situação como nós tivemos o ano passado, em que tivemos praticamente um ano sem uma gota d'água.
Es geht bei den Klimazielen nicht mehr um Diplomatie oder um ökonomische Grundsatzfragen oder um Klimamodelle. Es geht wirklich um den Schutz von Menschen, von ganz konkreten Menschen, deren Land, deren Erbe, deren Eigentum, deren Kultur. Und das ist diese Klage. Das macht diese Klage deutlich, für mich jedenfalls. Und deswegen vertrete ich sie auch mit vollem Herzen.
E por isso, a partir do momento em que percebi que havia a possibilidade de eu participar num processo deste tipo, acho que devo fazer isso. É a minha responsabilidade fazer isso.
Beh, credo che una delle cose che in Europa è possibile è il fatto che esiste una Corte europea a cui dei cittadini possono rivolgersi per ottenere qualcosa che credono sia interesse anche di tutti, no?
Il faut vraiment faire quelque chose avant que ce soit irréversible en plein, quoi.
Wenn nämlich hier anerkannt wird, dass der Klimaschutz ein Menschenrechtsproblem ist, dann kann der Klimaschutz auch in allen anderen Jurisdiktionen der Welt im Grunde aktiviert werden. Und das ist etwas, was den Klägern, mit denen ich darüber gesprochen habe, wirklich sehr wichtig ist.
Estamos a falar do nosso futuro, não é? Não só do futuro atual, mas essencialmente das próximas gerações. É possível nós fazermos um paraíso ainda neste planeta, não tenho dúvida disso.
Okay.
Talk about this massive open streets announcement you just made. You did.
I'm sorry. Let me just
enforcement.
stop.
So I need to understand.
Okay, Gerd.
I cannot hear.
Yeah.
I did not hear the question. There was a question, wasn't it?
There was a question?
No?
Not yet.
Not. Okay. Okay. I hope that. Can you hear me?
Yes, of course, yes.
Yeah. I think the video showed that the case is about real problems, real persons, citizens who do their work, mostly persons working in the agriculture. There are also other ones in the small tourist business. And this is very core at the case that the judges should learn about the real suffering of real persons. It's not an action of associations. It's not a theoretical debate. It's an action of real persons. And we have 10 families and one association, but a specific one suffering damage from weather changes. As I said, their occupation is medium-sized agriculture and tourism. There is a family living and working on a North Sea island, doing bio-based hoteling and restaurant. And there is a family far away in Fiji, a farmer, but also a tourist guide who suffers from the bleaching of corals. So different occupations, but all of them related to situations of experience of climate change. We who live in cities don't experience this very much as a personal problem. They do because they work with the environment. The geographical spread is from northern Sweden. There are reindeer herders over Central Europe to Kenya, a family in Kenya and a family in Fiji. If one summarizes the kinds of harm they suffer in terms of water availability, there are three situations: insufficient water, droughts, and so on in southern France, southern Portugal, in the Carpathians, and in Kenya. On the other hand, too much water, the rising sea level at the North Sea coast and in Fiji. And sorry, as a third concern, too warm water, one could say, in the Alps and in the northern European tundra, where snow disappears and the change of high and low temperature becomes more frequent, so that nature cannot easily adapt to it. The experience of the farmer in the Alps was that early in the year it was warm and his crop was already growing and was then destroyed by subsequent frost. On the other side, the defendants are the main institutions of the European legislature. and that is the European Parliament and the Council of the European Union. The European Commission, has asked to be admitted at intervener, which was granted. And in addition, Climate Action Network Europe also asked to be admitted as an intervener, but this was not yet decided. It will be decided once we go back to the first level, the General Court. I will explain this later. The stage of proceedings is the action was filed at the EU General Court in May 2018. In May 2019, the General Court dismissed the action for inadmissibility. We appealed against this decision to the European Court of Justice, where the case is now pending. There were some documents being exchanged between the parties, and the written procedure was closed in March 2020. We had a chance to apply to call an oral hearing, which we did on the 23rd of March of this year, and we are waiting for the decision of the European Court of Justice whether an oral hearing will be instituted or not. We would be very much in favor of this, because in that case we would bring almost all of the plaintiffs together to show them to the court and to let them experience how the court argues. Although the case is now only a procedural one, where it is argued whether the plaintiffs have standing, are affected in individual rights, it will be interesting for the plaintiffs to hear that in a way they are not accepted as plaintiffs for not being individually affected. This is very strange for them will be very strange for them to hear, because this shows, in a way, if looked at it from a legal sociological perspective, shows the distance between what an ordinary person would feel as legitimating an action, because he or she is individually affected, whilst the legal construction of individual concern, which is a precondition for admissibility of the case, is very different. It is very far away from the everyday experience of people. Now, what is the disputed matter? The core of the case is about the compatibility of 3 EU legal acts, which I, in the following, will call the Greenhouse Gas Acts, or GHG Acts, the compatibility of these acts with higher ranking law. And these acts are the following: a directive organizing what is called the emissions trading system. This is addressing heavy industry, the energy producing industry. The second legal act is a regulation addressing other sources of greenhouse gas emissions, other industry than heavy industry, transportation, buildings, agriculture, waste, and so on. And the third is concerned with emissions and sinks from land use change, and forestry. It's called the LULUCF regulation, LULUCF, standing for land use change, and forestry. The instruments aimed at by these 3 legal acts are different. The first is very much concentrating on the cap and trade instrument, where you cap, you limit the overall quantity of emissions a industrial sector is allowed to emit, and the different emission rights are then allocated to actors and can be traded if an actor needs more or an actor has the possibility of selling emission rights if he doesn't need as many as he acquired. The second legal act initiates a whole range of different instruments, for instance, in transportation, car emission standards, or in buildings, insulation standards, in agriculture, the use of energy, and so on. And finally, the third legal act is concerned with land use change. This relates to the change of land use from, for instance, forest to cropland, or from greenland to cropland, and so on. So if you cut the forest and burn the wood, this causes emissions and at the same time removes a possible sink for CO2, because the growing of trees binds CO2 from the atmosphere. On the basis of these three legal acts, emission quantities are allocated to member states. In the ETS system, a specific quantity is allocated by the Commission to the member states. The same, in a way, is true for the second system, where according to a certain calculation about the possibility of member states to share the burden of emission reductions, according to this calculus, every year the member states have a certain emission reduction obligation. And in relation to the LULUCF regulation, there is no explicit allocation of emission rights, but it is implicit in the system, because the regulation says that by 2030, that's the target year of all of these three instruments, there shall be a zero emission. So the emissions shall be equaled by the same amount of sinks of removal of CO2 from the atmosphere. So in a way, this is also the allowance of emissions, because at the time the sector has a negative budget, or in a policy, from a policy perspective, a positive budget, because more CO2 is removed from the atmosphere than emitted. And if the target shall be zero, this implies that the member states may emit more because they have a larger sink potential. So this is in a way also allowing more emissions. And what the acts now order is that the emissions within these three source categories shall be reduced. The year of reference is 1990, and by the year 2030, starting with 2021, the measures taken in during this decade shall ensure that the emissions will be reduced by 40% related to the baseline 1990. So if we take 1990 as 100%, this shall be reduced by 2030 by 40%. We are now already at a reduction by 20%, maybe even 22 or 23% in 2020. So the additional reduction is 20%, again related to 1990. The minus 40% is a sum total of various calculations, and within the three sectors, the ETS sector shall reduce its emissions by 43%. The second sector, the other sources, by 30%, and there's no reduction in the LULUCF sector. But if one combines all these different reduction targets, the sum total is minus 40%. Now, this sounds nice and ambitious, but it is not, because it implicates that in 2030, still 60% of the 1990 emissions will be allowed. And the allegation of the action is that this is insufficient, that the remaining quantity which is allowed to be emitted is too high, and that this is a breach of fundamental rights of the European Union and the Paris Agreement. So we can show this in this graph a little bit more clearly, I hope. If we take 1990 as the year of 100%, from which, as a reference year, the reductions are counted, then we have here a reality of reduction in 2020 by about 20%. So still available or possible emission of 80% related to 1990. The trajectory prescribed by the three greenhouse gas acts is this here. So reduction to 60%, reduction by 40% to this level in 2030. And measures shall be taken within this decade to bring the emissions down by 20 more percent to remaining 60%. The argument of the action is that higher rank law, by which the three GHG acts must abide, commands a steeper decline. And we will see that there are two different legal argumentations, one leading to a reduction by 80% to a remaining allowable emissions of 20% of 1990. And the other argument saying, okay, certain considerations have to be accepted, but still there should be a reduction by 60%, with 40% remaining. So this is on the overall goal of the action, and in more legal terms, one needs to be more specific about the relief which is applied for. The relief is that the court shall declare those provisions that set out the reduction targets to be null and void. The legal basis for such an action is Article 263, paragraphs 1 and 4 of the Treaty on the Functioning of the European Union. And this article, Article 263, first paragraph, says the Court of Justice of the European Union shall review the legality of legislative acts. We have here legislative acts, and the court is, according to this provision, competent to review the legality of such legislative acts. The content of paragraph 4 will be dealt with later on during my talk. This is sufficient to acknowledge at this stage that there is competence of the Court of Justice. There is a problem. This is also some kind of juridical intricacy. There's a problem if these provisions are declared null and void, then there is a legislative void. There's a zero of legislation. One could say then any emission would be allowed. But this is, of course, not to be wished, and therefore the treaty allows the court to order that although those provisions are null and void, they shall remain in force until better legislation, more ambitious legislation has been adopted. One could consider that why should we not apply for a mandamus order? Mandamus meaning that the court orders the European Union to change the law and introduce more ambitious legislation. This would not be admissible in our case. Such a mandamus action is possible when it comes to individual acts, but it's not applicable to legislative acts. There's no possibility to command the legislature to improve its laws. Only the declaration of nullity, of annulment, is possible. Nevertheless, there is some kind of mandamus possibility based on Article 340 of the treaty, but I will not go into details here because it goes too far. We don't have so much time. You will find some information about this in my article if you read it. The structure of the action is, as in any court action, that you have to follow two stages. One is you have to show that the case is admissible. At the admissibility stage, the courts filter out those cases that are not suitable to be decided by a court. And most often the intention is to avoid what is called the actio popularis, that everybody can bring a case against any decision for any reason of illegality. And then the second stage is the substance of the case. Whether the action is substantially grounded is then the question here. And in most cases, if the action goes against a public authority, the action is grounded if the authority acted unlawfully. I will, in the following, first treat the substance and then the admissibility. And the substance of the case needs to be treated in two steps. First of all, one has to identify the higher rank law which is applicable to the test of the lower rank law, the three GHG acts. And if we have identified those higher rank laws, we can apply them. So the first step is identification of applicable law, and then application to the case, application to the three GHG acts. And when it comes to the identification of higher rank law, we have two kinds: fundamental rights and the Paris Agreement. Let's first identify the applicable higher rank law, and here go first to the fundamental rights. The legal basis is the EU Charter of Fundamental Rights, which is binding for the institutions of the European Union, and for member states insofar as they implement EU laws. We have here a case which looks at EU legal acts. So we are looking at the question whether these laws are compatible with the EU fundamental rights. The rights invoked in our case are rights to health, occupation, property, equal treatment, and the welfare of children. There are some problems of doctrinal construction. I only go about more cursorily because, again, we have a time, we'll get into a time constraint otherwise. There's first of all, for the lawyers among the audience, not so much interesting maybe for non-lawyers, the question how to construe the legal relationship between the EU, the plaintiffs, and the polluters, those who emit greenhouse gases. One could say that because the emissions come from private parties, from enterprises and so on, that we have a horizontal case where the plaintiffs might either go against the polluters or go against the public authority, asking the public authority to intervene. In fundamental rights terms, this would mean the plaintiffs argue that the state has a duty to protect the plaintiffs, a duty to protect the plaintiffs against emissions from emitters. The other possibility of construction is that we say the EU has, in a way, taken up the role of a causer of emissions by seizing, in a way, emission quantities from the international agenda and allocating those emission quantities to the companies. And by doing this, interfering with the basic rights of the plaintiffs. So that would be a construction of the traditional two relation, legal relationship between the state and the plaintiffs as suffering from interference into their fundamental rights. The action takes the second construction first and argues the second in an alternative way. There's, of course, also a question of geographical scope of right holders. Are European basic rights applicable also in Kenya and Fiji and all over the world? This is, of course, a very controversial question which needs to be decided by the court. Our argument is, to the extent the European Union exerts public authority in other states, it must abide by their own fundamental rights. And they do this, the European Union does interfere, does cause damage by allowing and allocating emission rights. So this is an external reach of the EU action which binds the EU to its own fundamental rights. Of course, there's also a question of causality. Can the applicants really trace their damage back to action by the European Union? It's a very long causal link. It starts with the emissions within the European Union, which lead to an increase of the global temperature, which again changes the geophysical structures of the the climate, the conditions of climate, that again changes climate, and that again changes weather patterns. So it's a long chain, but on the other hand, we argue there's a proven causality. Any ton emitted of greenhouse gases will have a specific, maybe tiny, but a specific effect at the end of the chain, of the causal chain. When it comes to applying fundamental rights, one has to look at the structure, how such rights must be construed and applied. And it's a two-step structure. First of all, one has to show that there is interference with the protective scope and the level of protection of the fundamental right. And if this has been shown, there is not immediately the consequence that public action, state action or EU action causing this interference is illegal. There is always a second step where it is possible that an interference may be justified, and such justification is of course not in the discretion of the relevant state or international organization, but there is a precondition that such interference must be necessary to protect the public interest or fundamental rights of third parties. So this is the program we have to show in our case, that there is interference with the protective scope and that there is no justification of this interference. Now, first of all, is there interference with the scope and the level of protection of the fundamental rights? This is quite clear, and it has not been debated by the defendants nor by the General Court. There is, in our cases, health endangered from heat. If you look at the Kenyan family, they live in conditions which can go up to 50 degrees centigrade, and under such condition, the children cannot learn, cannot sleep, and the cattle suffers, and so on. So there's health, human health, endangered from heat. There's a serious loss of income. This relates to the fundamental right to occupation. And in some cases, one can even say that the essence of the right to occupation in the farming sector is interfered with. There is degradation of soil by flooding, droughts, and the removal of snow cover. And I could argue that in some cases, the plaintiffs even suffer from what is called indirect expropriation. If your soil is degraded and cannot contain rainwater anymore and is eroded, then you cannot make use of the soil anymore, and this comes close to indirect expropriation. The children's welfare is harmed, and there's also discrimination in two dimensions. One is of the children in relation to adults, and of the people in Kenya and Fiji in relation to Europeans, because Europeans are still allowed to emit much more than the families in Kenya and Fiji. There's harm to children's welfare also in the sense of bringing future generations in. There's no right of protection of future generations as such, but children in a way represent future generations, and therefore this case is also important to show that climate policy is something which will lead to serious damage, if not in presence, very certainly in the future. Now, when it comes to justification of the interference with public rights, which fundamental rights, as I said before, there must be shown that there is a public interest and rights of third persons, and there must be a necessity, if such interests are there, a necessity of interference with the rights of those who suffer from public action. A legitimate interest is certainly the energy supply. We cannot step out of coal-based energy tomorrow. There needs to be some time in order to ensure energy supply. And there's, of course, also a public interest in ensuring occupation, of ensuring jobs in those sectors which finally contribute to climate change rather than to protecting climate change from climate change. How about rights of third persons? This is a question to be debated. Is the European lifestyle, with its high degree of energy, a fundamental right? I would argue no, but maybe we can discuss this also looking at Spanish fundamental rights interpretations. So this is, I think, no legitimate interest which can be brought into the calculation of justification of interferences. But there is a public interest, of course, in allowing some emissions of greenhouse gases. The question is, however, is what is ordered by the 3 GHG actions, the acts, the reduction by 40%, is the remaining 60% necessary to protect the public interest. So here we are at a stage where we need to look at what is technically and economically feasible to reduce emissions. And if we look more closely at this reduction target of 40%, one can show that it was taken out of the blue. It's more a question of aesthetics. Every decade, there shall be a reduction by 20%. There's nothing substantial behind it. Of course, there were impact assessments set up by the Commission, and it showed that 40% reduction is economically bearable, but there was no in-depth research searching for what would be feasible, what the economy could tolerate, even if that costs a lot. And there's, in general, a lack of consistent methodology of how to find out what is feasible. Important factors were ignored, for instance, that one avoids costs of climate change effects if one takes measures against climate change. The whole area of sufficiency of lifestyle was not at all addressed. And now in the present crisis of the coronavirus, one can see that the people is willing to reduce its level of consumption, maybe not as radically as would be required under strict climate protection regulations, but there is a willingness. And this is not at all addressed by the Commission. And so we have looked at the relevant literature and the reports made by different think tanks, and many of them show that a reduction of emissions down to 50 and even to 40% is feasible. The conclusion then being that on the one hand, one could say reduction by 80% is or even more than by 40% is to be wished. But even if we apply the possibility of justification, the reduction by 50 to 60% should be declared economically and technically feasible. If we want to have a pure protection of fundamental rights against any interference, that would have to be much more drastic. But if we include a consideration of capability, of necessity, one still then one comes to a reduction obligation by 50 to 60%, leaving us with 40% still allowable emissions in 2030. The other argument, still looking at applicable higher ranking law, is international law, and especially the Paris Agreement of 2016. The Paris Agreement has a binding obligation to cite holding the increase in the average temperature to well below 2 degrees centigrade above pre-industrial levels. Of course, 2 degrees is already potentially catastrophic. This has been shown by the IPCC report of last year, which showed that if we go beyond 1.5 degrees, there's a risk of touching on what is called the tipping points, of touching upon points which really cause catastrophes in various respects. But in our case, which is a legal case, we cannot take 1.5 degrees limit as binding from the Paris Agreement, because it's only a limit which shall be tried to be attained, but not a binding limit. But 2 degrees can be taken even well below, could be taken, what we take in our case to be on the safe side, the increase of 2 degrees centigrade as the absolute limit. This limit allows to calculate the global emission quantity which is still available if the world wants to stay below 2 degrees centigrade. This allows to calculate a budget, which is a budget of greenhouse gas emissions, which is still available. And this overall budget must then, of course, be allocated to the different states. While this target is strict, there is language in the Paris Agreement which is more elusive when it comes to reduction measures. There we have language like that the state shall reach highest possible ambitions and take into account respective capabilities in the light of different national circumstances. And the equity principle is very often cited as a general principle of concerning the taking of measures. Now, if we compare this, the absolute limit with the more discretionary reduction measure obligations, we note a lack of fit. And we can deal with this in 2 ways. One can say, let's take the 2 degrees as really strictly a strict cap, which commands any distribution, so that respective capabilities means or is related to the absolute cap, which must be respected. And the other possibility is that we jump into the more discretionary language of the distribution, the reduction measures obligations, and say everybody shall do what he or she can, and we don't care much about the 2 degrees as an absolute limit. The application proposes both approaches in a 2 steps testing. One is we argue that there is an excess of the budget derived from the 2 degrees limit. So the 40% reduction is still exceeding the budget the EU may take from the worldwide budget. This is the first argument, and the second is a kind of fallback position. If we only look at respective capabilities and ask the EU to do what it can do technically and economically, disregarding the limits of the 2 degrees global budget. So that's an alternative fallback position, which very much resembles the second step in the fundamental rights argument, where we have an interference first and the possibility of justification of interferences. Well, if we apply this scheme, we need first of all to determine the EU budget and the way how this budget shall be spent. The EU budget as part of the worldwide budget, which is still available. And the argument goes like as follows. First of all, the global budget must be determined, and science suggests that this is about 667 gigatons CO2 for the year 2021. So this budget must be allocated to the EU. These 667 gigatons are the worldwide budget, which is still available, no matter when it is spent, still available if we want to stay below 2 degrees centigrade. Don't ask me how this was derived. This is, of course, a question of the scientists have to answer. And in the IPCC report of 2019, another budget was proposed, but based on different parameters. I don't go into details here. Let's take this value as the global available budget. Now, how do we allocate this to the states and in particular to the European Union? What are the criteria? As I said before, there are some criteria in the Paris Convention, and this could be relative capability, differentiated responsibility, path responsibility, and equal per capita. We propose in our case that equal per capita should be chosen. That is, that this overall budget must be divided by the world population and multiplied by the EU population. This results in an overall budget for the EU of 43.4 gigatons, based on about 6.5% of the EU in the world population. This is a middle value ranging from, depending on various questions of parameters and calculations, ranging from 22 to 65 gigatons. Of course, one can debate if equal per capita is a good criterion. But if you would apply respective capabilities and still have in mind that 2 degrees is the absolute limit, 667 gigatons is the absolute budget which is available, which cannot be expanded, then respective capability would mean much more reduction. One could say even within 2-3 years, reduction to zero. So, and the same is true for past responsibility and differentiated responsibility if related to this absolute budget I was mentioning before. So equal per capita is still a bit tolerant for the European lifestyle. If we apply this, we need to make a choice whether to take the average value or the minimum or the maximum. We took, for precautionary reasons, the lower value, 22. This is then the basis for the EU to allocate to the member states and to the individual actors. Now, this budget can be spent in different ways of digression of the annual emissions. And as the 3 GHG acts are applicable to the decade starting in 2021, one can then draw different ways how this budget is spent. One can think about a convex, a concave, or a linear way. Convex would mean we spend more now and will have less later. Concave means we reduce emissions drastically right now and save a little bit of residual emissions for later on. The EU legal acts take the linear digression as being the wise one. This means every year must show the same percentage of reduction. And if we apply this to the budget of 22 gigatons in a linear digression, then the budget will be consumed already in 2034, which means that in 2030, only 20% of the quantity in 1990 remains. We can show this here. We are here in 2020, de facto reductions, a bit more than 22%, 80% remaining. If we continue like we do now, no budget will be available in 2041. If we decrease linearly, this is the precautionary value, which ends in 2034 at 0, and in 2030 must be at 20%. Reduction by 80% and remaining 20%. We have also a table showing the emission budget if we assume an increase of the temperature by 1.5 centigrades. And you see here that if we take the precautionary, the average, or the maximum quantity, or and at 2027 at the latest. So this situation is more or less already inachievable. Okay, so our conclusion is that the reduction based on the budget calculation must be by 80% by 2030, with 20% remaining. This is, of course, very drastic, And in our action, we develop a fallback position, as I said earlier, applying again this criterion of technical and economic feasibility, disregarding the absolute limit of 2 centigrade temperature increase. And if we apply this, we are back to the reasoning we were before. The EU took 30% out of the blue. They didn't really look at what is feasible. They didn't develop a methodology. They overlooked certain factors which should have been taken in account as a possibility for further reduction of emissions. So our conclusion also from invoking the Paris Agreement is even if we apply a fallback position, we need to reduce emissions by 60% rather than only by 40%. So much for the substance of the case. And I would like to go into the question of admissibility, but let me first put the question to Mar. Do we still have time for the admissibility, or should I stop here?
Yeah, well, we have half an hour as much, well, including the debate. So maybe if you can try to short to maybe 10 minutes more of explanation, then we can just go to the debate, if it's fine for you.
Okay, let's do this. I'll try my best.
Okay.
So, as I said before, the court always will ask plaintiffs to show that they meet the criteria of admissibility, and this is in order to exclude actio popularis, the right to complain for everybody. And there are different systems in Europe how to reduce the possibility of going to a court. And the core criterion is individual concern of the plaintiff. And there are systems in Europe which understand individual concern to refer to the individual interest in a de facto system. And there are other systems which look at individual concern in terms of a right which shall be shown to be breached. The European approach is more, at least in the tradition until recently, goes more into the de facto direction, but in a very narrow way. The European interpretation of individual concern is that it must be a distinctive concern, a peculiar concern of the plaintiffs. And that is what's the basis for the General Court to dismiss the action. The court says, okay, many persons suffer from climate change, but this is not distinctive. It's not different from the concern of other persons. And this is, of course, applied to climate change. It's very unproductive. It's even terrible, because climate change harms innumerable people. So one could say this is not distinctive, but should, for that reason, access to the courts be denied. And the appeal against the General Court brings two alternative arguments. One is, please reconsider the application of this very narrow concept of individual concern. We show that the applicants are indeed distinctively concerned. Some suffer from too much, others from too scarce, thirds from too warm water, and one is cattle herder, one is crop grower, and so on. So everybody is in a distinctive situation. I don't believe that the court will accept this. In the alternative, we argue that the interpretation of individual concern as required by the Treaty on the Functioning of the European Union shall be changed. So individual concern should be interpreted differently. Instead of distinctiveness, we propose to introduce the criterion of seriousness of concern. And there are a number of arguments we bring in favor of this, the need to change. And the defendants respond that the treaty itself was changed. The Lisbon Treaty was changed in 2008 without changing this criterion of individual concern for actions against legislative acts. This is also expressed in the famous judgment of the European Court in the Inuit case, but we argue that individual concern as a wording of the treaty is open for reinterpretation. The fact that the formula was not changed was based on a discussion within the convention, the group of discussion of constitutional lawyers, and the president of the European Court at that time, Iglesias, was asked, should we change anything concerning action against legislative acts? Isn't this a constitutional action? Should we change something? And he said, no, we don't need this. Let's wait for the court to develop some criteria. So this is no good argument. The fact that this wording was not changed is not to be interpreted to hinder any new interpretation. Then there's an argument brought from our side that without direct access in our case, this would be a violation of Article 47 of the Charter of Fundamental Rights, which establishes a right to legal protection, a right to access to courts in order to protect one's individual rights. The defendants respond also based on jurisprudence of the European Court of Justice. They say, why don't you go national, go to a national court and ask the court to submit a question for a preliminary ruling on the basis of Article 267. So that is a possibility you have, which shows that there's no violation of the guarantee of legal protection under Article 47. Our argument against this is that in our case and in our type of case, the national court would not test the constitutionality of the underlying EU acts, because in the climate protection area, the member states can go further. They have the possibility to reduce emissions within their jurisdiction by more than 40%, based on Article 193 of the treaty. Then the defendants say, well, yeah, but why don't you take action then to compare the member states to make actual use of their powers to go further and to reach more reductions than by 40%. And we replied to this argument saying that this would mean that we have to take action in 27 member states in order to increase the entire EU target of 40%. And this is not in the sense of providing the guarantee of access to courts. And it is not the aim of the plaintiffs to urge member states to go further. What they want to do is to increase, to make the EU target more ambitious and to invoke EU fundamental rights as a command to do this. Okay, so this is the state of admissibility argumentation. There's another question of association action. I leave this out, and there is a question of direct concern. The plaintiff must also be directly concerned, but I think this would go too far. One could also discuss whether the court should come in, whether this is not a political question to be decided by the legislative branch. But I wait for comments from the audience, and I'm sorry to have taken so long, but things are rather complicated, and well, I tried my best.
Thank you very much, Dr. Winter. Thank you very much for this nice presentation. I think that there may be quite a lot of questions. So we have, yes, more than around 20 minutes to for our debate. So I would like to open the floor. If any one of you wants to put a question or wants to make some contribution, what I suggest is that you can do it both ways. You can do it directly. So please just raise your hand, and then I will give you the floor. You need just to activate your micro and your camera, or you can also use the chat tool. So, any questions for Professor Winter? It may be both in the substance or in the admissibility issues. Maybe we can also use this few time to, well, to go on some questions on the admissibility or whatever you would like to contribute. So anyone who wants to start? Well, so let me, okay. Here we have Professor Peñalver. Please just go on and remember to go on. Maybe, sorry, Gerd, you can just stop the presentation? Okay. Sorry, just technical. Oh, no, better. Thank you.
Hello. Thank you very much for your brilliant presentation. No, it's there are a lot of questions here, and I think that. But just I would like to have I have two questions. First is the why you didn't use so much maybe the 37 article of the European Union of Charter of Fundamental Rights, no, in order to try to get a stronger interpretation of the protection of environment, just not only as an obligation to the public powers, because maybe if we link this article with Orhus Convention, maybe we can say that there is a human right, environmental human right, not just only a public mandate, no. And the second is I understand that with this case you are trying to get a broader interpretation of the individual concern, and for the reason you choose individuals, no, and only that they have some rights, individual rights affected. But maybe it could be interesting also to bring to the course environmental NGOs in order also to try to change the interpretation of the individual concern also for environmental to protect the environment, no? And I think this is important also after the Client Earth case to the Aarhus Compliance Committee, no? That the last the European Green Deal, no, says that we have to change the Aarhus regulation, or we have to pass new regulation, no? But maybe with this case, maybe you can try also to change the jurisprudence of the European Court of Justice, and for the reason maybe why you didn't use environmental NGOs in order to protect environment from climate cases.
Okay. Yeah. Sorry. Maybe may I just suggest, because I have also one question from the chat and another question from Professor Isabel Pon. Maybe I can probably just go first on the questions, and then you may try to answer the different questions. Would that be fine?
Yes, of course.
Yes, okay. Okay, then I have a question from the chat from student Carlos Puente. He says, firstly, I would like to thank Professor Winter for his presentation. I have two questions. The first one is about the origin of the case, how it was born. And then I would like to know, what do you expect from the European Court of Justice? This is the question from the chat. And also, now, if you allow me, I will give the, I don't know where Isabel, she's not asking there anymore. Okay, so I don't see now, she's, okay.
Yes.
Just go on.
Okay, I would hello to everybody. Thank you for organizing this meeting. It was not exactly a question, it was just a comment, because I assume that most of people here are students of environmental law, of European environmental law, taught by Mark and Vince, and is only to tell them that they should keep studying this subject, because as you could recognize, environmental law nowadays is not only needed, it needs to have some aspects coming from international law, from European law, from member states, domestic law, procedural and non-procedural knowledge, and I'm sure that they will be kept with passion if they continue studying this area. Having said that, I would like to congratulate Gerd Winter, because I think he has been, or you have been, very, very brave, bringing or helping or representing the people of this case, because this needs a great amount of creativity. You are braver than most of us, because at the beginning, if anyone had told us that this case would be brought to the court, we would have said, no, it's so difficult that it's almost impossible to go through. So I think after listening to you, I've been thinking about other cases that we have studied many times, like Lopez Ostra and many others, that we thought at the beginning that they would not be successful, but someone has to start all this work, and you are the one who has started this at the European Union. Maybe you don't succeed, but we should not be depressed, because this is step-by-step work. And I don't know what will happen at the end with this case, but we have learned many lessons already. The European Union itself has learned with this case many lessons, because, for example, they will have to take, or if I were at the Commission, I would do it, to take more seriously all these international commitments, all these directives and regulations which are being passed, and if they don't include enough allocation of budgets, they are not important enough, and they will not be properly enforced. Just this comment, and thank you very much for your talk and for representing these people in such a beginning of this fight. Thank you very much.
Thank you, Isabel. I still have two more questions that I'm also putting here. So first question means, first question is actually more a comment, but it's also a question. This is a great example, I think. Well, first, it's a great example of knowing for the students how to work a case from the inside. But then it's also, I think, an example, a clear example of experts from different fields working together. Because, of course, when we were talking about the substance and you were meaning about different criteria for allocation or the different ways to act for the budget, the concave, or the convex, or the linear ways, and I guess, and I assume that that requires the collaboration of experts from different areas. So I was curious to know how was this cooperation with other experts, because here we have students, of course, most of them are from the law or have a law background, but we also have students or professionals coming from environmental science or engineering, agricultural, and even we have people from the science of the sea, masters. So how that works between lawyers, the more experimental experts. And my other question is concerning the admissibility issue too. To what extent are you really confident that the court position can change the diploma test? I mean, I'm thinking, as you mentioned, in the case of the Inuit community, which of course not on the substance, but probably yes on the admissibility issue, the court really hold the more traditional position. So I'm not sure if there is so many more questions. Let me just see. Well, I can. No, yes, no. So it's, it seems that that's. Let me just. There is still another question from the chat, and that will be all the questions we will put right now. Professor Gerd, it's from Professor Mara Aguilera. She says, Professor Gerd Winter, thank you very much. It was so interesting. Also from a constitutional perspective, I have to teach online in another course right now, hoping to be able to discuss such issues. So it's not a question, it's just danke. It's just a comment. Okay, so maybe you can just go on your answers if there is no more questions on that. Okay. May I ask the other people to close the micros, please, just to disable the micros, so that, thank you very much.
Yeah, thank you very much for these questions, which are raising very important issues. I start with Article 37 of the Charter of Fundamental Rights. That is the provision asking the European institutions to protect the environment. But as you know, this is not a fundamental right as such. It can be used, this provision can be used in order to interpret the individual rights. And we did this in the application. In more general terms, one could, of course, discuss whether there should be an fundamental individual right to climate protection or to environmental protection in general. There are, I think, about 100 states which have such a general right. In our case, first of all, we did not need this because we have individual plaintiffs which can really show that they are individually affected, interfered with in their fundamental rights. And on the other hand, the general right to environmental protection is very dependent on interpretations. What is a good state of the environment? So we didn't venture into that question in order not to overload the doctrinal difficulties of the case. But I agree that Article 37 must play a role in an environmental reinterpretation of fundamental individual rights. Concerning the question of NGOs, we do have an NGO here. This is an organization of young reindeer herding, of young members of reindeer herding families, but we only argue on the basis of the existing conception of association actions, which is that an association must also show that it is individually affected in their property or whatever. We say that one of the exceptions the Court of Justice agrees with applies, that is, an association action is possible if all of the members have also individual standing. And that we argue this is the case because all of the members of this youth association belong to reindeer herding families. We add something new, that is, we say that the kind of association which is acting here is different from a professional association, which in a way represents the individual interests of professions like a lawyers association or an industrial association. We say this is different here because there's a sense of community of the reindeer herders. The community is owning a right to make use of properties, even of private property of other persons, for the herding, for the grazing of the reindeer. This is a community right, and this is a collective right which is brought by the association. And we argue that the Court of Justice has never thought about such kind of, in a way, rights of traditional communities. We did not go into the Aarhus reasoning because the Aarhus Convention is not applicable to legislative acts, and we are bringing legislative acts to courts. So we could not argue that the Aarhus Convention, let's say, for instance, Article 9, paragraph 3, orders also the European Union to allow association actions against legislative acts. And the ongoing debate based on the ongoing debate of reforming the regulation 16, what is it, 67 or whatever on NGO rights to appeal against administrative acts. This is not in the scope of our action. And the next question was what was the origin of this action? Well, it was more or less my own kid, my own baby. I had the feeling, having also 6 grandchildren, I need to do something about their future. And I then started to get into touch with possible NGOs, and there's a wonderful small NGOs, Protect the Planet, which immediately supported the case and said any costs will be borne by us. I myself do this pro bono. I don't get any money for it, but of course we have a lawyer, Rhoda Verheyen, the lady who was shown in the video. She must survive as a lawyer, And we have a third person, Hugo Leith, a barrister from London, who is experienced in general court proceedings, but he also does it pro bono. So there is not that high volume of courts among the lawyers. I come to the scientists later on. Then there was a question, what do you think about, did I hear correctly, the corrupt European justice? Was that the question? No.
Not about the corrupt European justice. I think I was thinking on the plowman. I mean, if the European corrupt.
No, this was your question. This was your question. Yeah, but I had the feeling there was a question about the corrupt European justice. I was a bit.
No.
There was no. Okay, Isabel Pont, thank you very much for your encouragement, both of students of environmental law and of myself for bringing the case. We have been in touch not very much since, for at least a decade, but I think there's still the feeling of good companionship, and thanks for that. And I only can subscribe what you said about encouraging environmental law students. And this is very important because you, at least for a time, acted on the side of the industry or the port authority, allowing also to make use of the environment. So that's important to know from an economic law expert about the necessity to also take the environmental question into account. Now, the question on the law-science interface. This was a very interesting experience. We had really very intensive contact with scientists, and as always, there are great difficulties of mutual understanding. The language is different, the perceptions are different, the policy proposals are different. So it was really difficult, but if you carefully look at differentiating science or fact-based questions from normative questions, you get along. Science-based is, of course, the question of how do I calculate the budget. Normative is the question, how do I allocate the budget? These are normative questions, but if you decide that such and such criteria shall apply, then you go back to science. If you decide to apply equal per capita, then you must count what is the population and so on. If you decide in favor of respective capabilities, you need to cooperate with economists to see what can be done and so on. So that's a real challenge, but very important to do. And there was one advice I took from Dennis van Berkel, the core lawyer of the Ogenda case, and he once said, there are these thousands of pages of expert reports, and unfortunately, you need to read them yourself. Mm-hmm. And it's a high load, and it took me at least 2 years full work to get through all these debates and contributions to finally come up with something simple, because the court needs to have something very simple. This is a capacity of the European courts, but it's also, of course, a heavy burden for lawyers. Now, what are the chances of a change to Plowman? You refer to the Inuit case, where local people found themselves restricted because there was a restriction of the sales of seal,
the steel
products. Steel products. Well, in that decision, the court refused to adopt a new criterion, to change the interpretation. And the plaintiffs indeed proposed something we also propose, to change the individual concern as interpreted with Plaumann, distinctiveness criterion, by something like serious harm. We add to this serious or harm interfering with the essence of a right. If that is the case, at least there should be admissibility. Now, the Inuit case could, in a way, indeed recommend in that case, the court could recommend the plaintiffs to go national, to raise a national action, and then propose a preliminary ruling. This is so because we had here a traditional situation of interference with individual rights. There was a restriction to trade, which led to the inability of the Inuit to sell their goods. And this can, first of all, of course, brought to the national court, which then feels that the national administration is obliged by European law to restrict trade. And then, of course, the national court will submit a question for preliminary ruling about the compatibility of the EU law with EU primary law. In our case, we have a different situation. There is empowerment of, no, there is law which leaves the member state to go further. And this means that the national court, if invoked, will have to look at constitutional obligations to go further or not. The national court will apply national fundamental rights, not EU fundamental rights, and will also have not the need to check the constitutionality of the EU legal acts, because he is only asked to judge on whether the national government shall go further. So this is a different constellation, which will make it impossible or improbable for the European court for the national court to go European. And after all, the applicants, they want to challenge the EU legal acts. They want that the EU once for all and for all member states goes further. And they want to test the EU fundamental rights. So much for this question. And maybe as a final remark, I had a debate with a friend of mine who wrote an article, very aggressive article against this case and other climate protection cases, saying you raise expectations among the public that the courts will do anything. Why don't you refer to the democratic process that must be used? The democracy and the legislature is the branch which is responsible. And my simple answer is, we have fundamental rights which are also addressing the legislative branch. And of course, we must be aware of the need to respect the political process. We must recognize that, first of all, democracy and the parliament and so on is responsible, but they are not without limits. Fundamental rights have also something to say to parliaments, and especially to the European legislator, because it is very much dominated by the council and not so much by the parliament. The council is more or less an executive power, and that at least must be guided by fundamental rights reasoning. We are not so naive, of course, to overlook that the whole process on the EU level is a political one. There's a political game between different countries. Poland very much in favor of coal-based power, and France on nuclear, and so on and so forth. There's a political game, but even the politicians, the ministers which come together, even the leading persons, they need to know that they are not unbound, that they are bound by the EU fundamental rights. After all, they have established them. Why? Why also for the legislative acts? Yes, because they wanted it. So please do what you did.
Okay, thank you very much. So I think that we are a little bit out of our time. So I think we can close with that final reflection that you just make. Most of the students are saying, thank you very much, Professor Winter. So I'm just, well, giving you the same way. So it looks like we have succeeded despite the difficulties to have our conference, for what I really thank you a lot, Professor Winter, for being here today, for sharing his time and his experience today with us. We are just having some comments on the chat tool saying thank you very much, Professor Winter. I just want you to tell that also. And I also, of course, want to thank you all the people who was here in our session today, who attended the conference, especially all the students from the different degrees, masters, PhD programs, professionals. We really had a very nice group of students today here, coming from different backgrounds. I think that is always positive. And of course, I also want to thank here the University of Barcelona for well, making available this platform. Maybe it's not the, I don't know, it worked well. That was what is important. We also have some students from Germany, Erasmus students, that I also saying thank you very much, Professor Winter too, on the chat too. So I think that now we are out of our time. So I just want to again thank you very much. And I also didn't say that before. This is one of the activities from the Jean Monnet chair on European environmental law, so that we are still trying to keep on our program ahead, even with this new format. But I really think that today we had we had more than 80 students, and I think that was really a success. And if it was a success, it was because of you and your presentation, and of course the interest of that case. So thank you very much, and thank you to all of you. And we are now going to close that presentation. You can watch again the presentation if you wish on our campus virtual and on the website. Okay, so yeah. Professor Winter, thank you very much for staying here with us, and for the previous session of training that we had these last weeks, but finally everything worked fine. Okay, perfect. Okay.
Thank you, Mar. That's great, your guidance through this technical and substantial conference.
Thank you very much.
Bye-bye.
Bye.